Welcome to everyone who is joining us today. I'm Julianna Gesiotto. I'm a staff attorney at the California Women's Law Center. And as mentioned, I'm joined by my two co-hosts here, Jessica Lee, who's the co-director of the Center for WorkLife Law at UC Law San Francisco, and Brenda Vieyra, who is a lactation consultant and an infant feeding liaison at Breastfeed LA. Thank you both for being here with me today, and let's jump in and get started. So first, we're going to discuss kind of why this topic is important for parents and pregnant and parenting employees. We're going to focus first on pregnancy accommodations, and then we'll move into pregnancy leave and end with lactation accommodations. So to start us off, there are some reasonable accommodations that many pregnant and postpartum employees do typically request. These can include things like permission to eat or drink more often than non-pregnant employees, extra rest breaks, restroom breaks, or lactation breaks. Sometimes pregnant and parenting employees, they have lifting restrictions, maybe due to their pregnancy or due to recovering from C-sections, for example. Sometimes they'll need permission to sit or stand in a job that traditionally, you might have to stand all day. You might request sitting. And then there's also time off and leave requests that have to do with pregnancy itself and child care, as well as disabilities or conditions that relate to pregnancy and child care and to lactation. And then finally, the last note we have here is the protection from retaliation and bias for requesting these reasonable accommodations. So we'll get started now with the California protections for pregnancy accommodations. This is generally found in the Fair Employment and Housing Act, or FEHA. And FEHA says that it is illegal to discriminate in the employment sphere based on sex. And sex includes pregnancy, breastfeeding, or medical conditions related to either. And I really want to highlight that this includes pregnancy or breastfeeding on their own and not just disabilities and conditions related to those things. Employers are required, therefore, to provide reasonable accommodations for employees who have these conditions related to pregnancy or childbirth, and that includes lactation. Just like in the disability context, for example, a reasonable accommodation is an adjustment to an employee's work environment that enables the employee to perform the essential functions of their job without undue burden to the employer. So a lot of what we just talked about in the last slide would be considered reasonable accommodations under FEHA for pregnant and parenting employees.
So those of you here in California are probably a little bit familiar with FEHA, but I do want to bring to your attention that there is a new federal law, which also gives rights to reasonable accommodations related to pregnancy. The Pregnant Workers Fairness Act was signed December 29th, 2022, went into effect last year, and then a couple months ago, we got the implementing regulations from the EEOC. So this is a fairly new law, but I'm really happy to bring it to your attention today, those of you who aren't familiar, because I have heard in conversations with advocates and even a couple attorneys that we don't need to pay much attention to the federal law because FEHA is so strong. FEHA is fabulous. I am very proud that we are already very familiar with providing pregnant employees with accommodations in California. But I do want to flag that there are many circumstances where the Pregnant Workers Fairness Act is more protective. You'll probably hear I often abbreviate the Pregnant Workers Fairness Act as PWFA, which is not very elegant, but there we go. DC talk for you, PWFA. So the Pregnant Workers Fairness Act applies to employers nationwide that have 15 or more workers. So very similar to Title VII, looking like the ADA there, that's our general threshold federally. And it does also, just like FEHA, requires employers to provide reasonable accommodations for employees with pregnancy-related conditions. I do want to flag that the list of pregnancy-related conditions under the Pregnant Workers Fairness Act is very broad. So it includes past pregnancy, potential pregnancy, and current pregnancy, right? So fertility treatment, folks who are receiving care to become pregnant would be covered by PWFA. People who have miscarriages or an abortion and need changes at work or time off of work as an accommodation would be covered. And one of the big differences here with some of the other laws you might be familiar with is that the Pregnant Workers Fairness Act includes protections for folks who need changes just to manage their well-being. So for example, avoiding pain is covered under the Pregnant Workers Fairness Act. Very simple needs that pregnant workers have, which might not even be diagnosed, definitely doesn't need to be a complication, it doesn't need to be a severe or continual condition. It could just be avoiding discomfort, could all be covered under the Pregnant Workers Fairness Act. So the range of conditions covered is extremely broad here. And it can be very, very useful, especially for folks who are in those early stages of pregnancy. One of the reasons that's so is because in the federal context under the Pregnant Workers Fairness Act, unlike under California law, the accommodation requested does not need to be under the advice of a healthcare provider or physician. This is especially going to be helpful for workers who are low wage earners, who don't have regular access to healthcare. There are going to be some changes that those workers will be entitled to under the Pregnant Workers Fairness Act that they might have a hard time getting under FEHA, just because they're not able to go to the doctor quite as often. It's also really helpful in the early stages of pregnancy, where we see workers who, for example, need to eat and drink more often or use the bathroom more often, or maybe they're just really fatigued or experiencing morning sickness. Very common discomforts, impairments, or complaints that we see in early pregnancy that a lot of doctors are not going to make time to have an appointment for. We see a lot of folks who need help as early as 6, 7, or 8 weeks of pregnancy. When they're just getting their very first appointment, it's hard for them to manage more appointments quickly. The Pregnant Workers Fairness Act is a great answer for that, because you don't need the advice of your healthcare provider or physician to ask for the accommodation. And also, because of some great documentation standards, which I'll talk about in just a second. One of the other reasons why I'm such a big fan of this federal law is that the Pregnant Workers Fairness Act identifies predictable assessments. Those are accommodations that will virtually always be reasonable. And that includes a few of those things that I just mentioned that folks often come in needing support for. So that's carrying or drinking water as needed, accessing additional bathroom breaks, sitting or standing as needed. Very, very helpful for folks who are experiencing back pain or swelling. And then breaks to eat or drink as needed. The EEOC has made very, very clear in their implementing regulations that these are so common and predictable that it will be extremely rare for there to be an undue hardship in these instances. You can presume that that employee should have been covered. To match that, the documentation standards also take these into effect. So let's dig into that. So the Pregnant Workers Fairness Act documentation standards are another departure from what we often see under other laws. For example, I have a lot of workers who call the Center for WorkLife Law's helpline because they need help getting accommodations, and constantly see the sticking point being getting a physician's advice, getting their doctor to fill out forms. Often that's because the workplace is using super lengthy ADA forms for their pregnant employees. Hopefully, with the Pregnant Workers Fairness Act, that should be a thing of the past because PWFA has some very clear limitations on what documentation employers can require. So employers can only ask for certification when it is reasonable under the circumstances to do so. And the department or the EEOC has made clear that it's not reasonable to ask for documentation when the need for the accommodation is obvious. So for example, if someone has a worker who's 9 months pregnant, can't fit their uniform, they should not be required to have to turn in a note saying this patient is 9 months pregnant, can't fit their uniform. That is very obvious, right? It's also not reasonable to ask for documentation when the employee has already provided sufficient information to substantiate the need. So for example, if someone in early pregnancy is having morning sickness, and they get an accommodation for that. Do they actually need documentation that reiterates their due date later in their pregnancy? Probably not, right? If they've already turned over enough information, you don't need to ask for it again. And then finally, documentation cannot be asked of an employee when that accommodation is for one of those predictable assessments that I just mentioned. So that's the bathroom breaks, carrying water, permission to sit or stand. We've also added lactation breaks or space here. So employers cannot require notes for a worker to access lactation break and space or additional food breaks throughout the day for their pregnant workers. So there's a limitation on when employers can even ask, and there is also a pretty worker responsive limitation on what the employers can ask for. The extent and type of the documentation itself must also be reasonable. So the documentation required can be limited to documentation that would confirm or describe the condition, that it's related to, affected by, or arising out of pregnancy or related conditions. Again, that's viewed very broadly, and that a change is needed. You do not need, or an employee would not need to say, here is my diagnosis code, here's all of my medical records. They don't need to go into extreme details about the condition that they're experiencing. It's very, very limited, just flagging that there is this condition, it's related to pregnancy, and a change is needed. And it really can be as simple as including 3 lines. I also want to flag that a variety of healthcare providers can certify here. Everything from midwives to physicians, doulas, lactation consultants. It is extremely broad. And even someone who is not the treating provider, so long as they're familiar with the patient's records and needs, can even certify. So for example, if someone's primary care provider knows that this worker has postpartum depression, they can write a note for it. You don't have to send that patient back to their therapist to get a note. It will suffice to have their primary care provider offer it. I have just packed in basically 45 minutes of an in-depth presentation into 2 slides. I know that's a lot. For those of you who are working with a lot of pregnant workers who might be in need of workplace changes and want to know more about these documentation standards, we have this link here, and that is, I think, really, really helpful to share with the healthcare providers themselves. We often see healthcare providers shy away from providing the work notes that patients need to keep their job and stay healthy. But I'm hopeful that by offering them a template form and simplifying this for folks, they'll be likely to certify and to get it right when they do. So in summary, Pregnant Workers Fairness Act It has more worker responsive documentation standards, and can be used very broadly. And but let's dig into a scenarios to apply this. So Maya is 6 months pregnant and works as a grocery store cashier. Because of her pregnancy, Maya needs to use the bathroom frequently during the workday. She let her boss know that. Her boss says that she has to just hold it because there aren't enough staff to cover her posting. And when Maya insisted that she be accommodated, her boss told her that pregnancy is not a disability and she needs a doctor's note if he is to accommodate her. What are Maya's rights? I hope this is glaringly obvious here. Maya does not need to just hold it. Uh, Juliana, what would you say under FEHA? What would Maya be looking at here?
Sorry about that. Yes, so I think even under FEHA, I think that Maya's boss is still in the wrong here. While he might have an argument that, she still needs this disability note, I think because FEHA does protect against discrimination against someone who is pregnant, it would there's a good argument that there's a violation there. And the boss himself can cover her position while she uses the restroom for a few minutes every day.
I love that mention of the coverage. Absolutely. It's the employer's obligation to provide the coverage that the worker needs. Um, at a grocery store, the idea that a worker can't take 5 minutes to run to the bathroom, I think is pretty extreme. So this definitely sounds like a reasonable accommodation to me. And just a reminder, especially under PWIFA here, this is very clearly a need that would be covered. So again, the pregnant worker's health condition doesn't have to be a disability. It doesn't even have to be a complication or a so-called problem, nothing unusual. Just the fact that she has to go to the bathroom more frequently due to pregnancy would entitle her to an accommodation. And then again, under that federal standard, she would not need a note for this. So if the employer were to take any adverse action against her, that would be a pretty big red flag here. And then, of course, Maya could come to you for help getting the accommodations that she needs to make sure that she's not having to choose between protecting her health, the health of her pregnancy, and her job.
Great. All right, so now we're going to move on to talking about pregnancy leave and a little bit about postpartum leave as well. So in California, we have a couple different types of leave that are pulled from various different benefits and different laws. So I'm going to kind of give a brief overview of all of these before Jessica discusses the additional PWIFA protections that apply. So in California, there's pregnancy-related disability leave. This can be through FEHA or through PDL, which just stands for Pregnancy Disability Leave, which guarantees job-protected leave to eligible employees who are disabled by pregnancy, childbirth, or a related condition. Leave, you can get paid leave in California as well through disability, through SDI or NDI, but note that SDI, state disability insurance, you do have to be paying into it from your paychecks in order to receive those benefits. But regarding pregnancy, usually you can get about 4 weeks pre-birth of SDI, 6 weeks after birth, or even up to 8 weeks for C-sections, and those are just averages. When you receive SDI, it's about 60% of your salary, but it alone does not guarantee job protection. However, you can get SDI while having job protection, under FEHA, PDL, or FMLA or CFRA. So regarding those, caretaking and parental leave, FMLA and CFRA, CFRA, the California Family Rights Act, something like that. Sorry, I don't remember the acronym. But CFRA typically guarantees up to 12 weeks of job protected leave. However, I think it's really important to note that CFRA protections will only kick in after an employee has worked there for usually it's about a year before they have those benefits. And then again, STI you can get paid leave through PFL, which is paid family leave. And then let's move on and talk a little bit more about WIPA.
Yeah, so one of the reasons I often encourage folks to look at the Pregnant Workers Fairness Act for leave is because the reasonable accommodation requirements also include leave. Workers can be entitled to take time off under PWIFA. But thankfully, unlike a lot of the other laws that provide job protection for employees, the Pregnant Workers Fairness Act does not have any length of service eligibility requirements. So a worker who has only been employed somewhere for 5 or 6 months, for example, would still be entitled to job protection if they need to take time off due to their pregnancy. So that is a great fit for the many workers that we have out there who are otherwise ineligible for job protected time off. It also doesn't have those hourly requirements. You don't have to hit the 1250 hours or any of that. It's very generous so long as it doesn't cause an undue hardship on the employer. So if you have a client who does need time off, make sure that the fact that it's because of pregnancy is known and documented to the extent you can. You will probably need some documentation for that. I always encourage clients to select an end date with their healthcare provider, even if it may be reevaluated, because that tends to diffuse employer defensiveness or concern about that. I know often we have employees who have they just don't know how much time they're going to need. I encourage selecting an end date and reevaluating if needed. But I do want to flag that another great provision of the Pregnant Workers Fairness Act is that in the EEOC regulations, there's a lot of very helpful language about the fact that pregnancy-related conditions are typically, by their very nature, definite, right? They're not an indefinite condition. So unlike the ADA, where there is much bigger concern about indefinite periods of leave or the suspension of job qualifications, we actually don't have that under the Pregnant Workers Fairness Act to anywhere near the same extent. There is a presumption that accommodations that will last for less than 40 weeks are considered in the near future, not going to fall into that prohibition on indefinite leave that we're all probably familiar with from the ADA context. So, typically if someone has that pregnancy-related condition, it's going to impact them for 40 or fewer weeks. Some people it will be longer, of course, but definitely check out the EEOC regs on your timelines here because I think it is more generous than a lot of us are used to, those of us who work in the federal context. And I always want to remind folks to remember that employers can't force their employees out on leave if they didn't request it, and an alternative accommodation can be provided to keep them working. If you ever see an employer who gets hit with an accommodation request and their first response is leave, that should be a huge red flag for you. Most workers can't afford it. Calls to our helpline, it's relatively rare that that's people's first choice because they do need that full income to keep working. So I would absolutely dig into that further the second you see that red flag go up because there's probably trouble there. So let's talk a little bit about leave in practice. Under the Pregnant Workers Fairness Act, just like under FEHA and a lot of similar laws nationwide, we know that we see retaliation for folks taking leave. Even people who get permission to take that time off might be coming back to a different workplace in terms of the bias that they're facing. So that's another thing to keep a sharp eye out for. I also encourage you to take a look at quotas and performance metrics. Make sure that those have been adjusted to account for an employee's time off. In the PWFA context, the EEOC has made clear that you have to adjust metrics to ensure that an accommodation is truly an accommodation, right? Not just a kiss of death for an employee who's then going to be put on a PIP and pushed out of their position. So here are a few examples of that. A car dealership upholds quarterly sales quotas for all salespeople employed there, but adjusts the sales quota for its employee on maternity leave to be proportional with the time she was actually working that quarter. That is exactly what we want to be seeing. We don't want workers coming back and being told, hey, your points are low. Welcome back from maternity leave, but here's your 2 weeks notice, right? Another example is a nurse working in a hospital that has pregnancy complication that requires weekly doctor's visits during one of her normal shifts. The nurse's manager covers her weekly shifts and does not consider her missed shifts when deciding on an upcoming promotion. I hope this sounds realistic and not like a fairy tale. It's so wonderful to hear some positive examples. Again, this is exactly what we want to be seeing. And then again, there's a little bit of duplicity here amongst the laws, but remember, the various laws do protect against retaliation. We don't want to see any of these workers return back from pregnancy leave or coming back from other accommodations to face adverse employment actions. I always tell our callers to trust their guts. Definitely, if they're raising a red flag that something just isn't right in the workplace after requesting accommodations or leave, there's a pretty good likelihood that that employer is violating 2, 3, 4 laws because this is clearly prohibited.
So we'll review another example. In this scenario, Andrea has taken intermittent leave to get care for postpartum depression. She coordinates her leave with her supervisor to find the best times to accommodate for the team's workload, which she doesn't have to do, but she is doing. Upon Andrea's annual review, she is marked down on her review due to missing important work meetings and events that occurred during her leave. Andrea's gut is telling her that's not okay. She expresses to her supervisor that it's not legal or ethical to lower her performance due to the missed activities while on leave, and that were agreed upon. And after her supervisor explains, oh, you are entitled to your leave, but still missed the meetings. So Andrea requests that that statement then be written down on her performance review if the supervisor is continuing to reiterate that these missed meetings are impacting her performance. And so Andrea's supervisor removed the comment about the missed meetings while on leave, but maintained the poor review. So especially given everything Jessica just reviewed, it should be pretty obvious that this is like a form of retaliation. Or can be viewed. And again, that's violating the many laws that have already been discussed, PWFA, FEHA, FMLA. And so hopefully these scenarios can help you understand and see real life examples of how something, is violating the law.
And to reiterate, especially under, or I shouldn't say especially under PWFA, I'm less familiar with FEHA than I am with PWFA after digging into those thousands of pages of regulations for the last few months. But I should say under WIFA, if your client is entitled to an accommodation, that means being entitled to adjustments that make that accommodation possible, right? And so this would definitely be raising red flags for me. I'd also be looking at FEHA violations, FMLA violations, if they've just come back from their FMLA leave. But it doesn't always look quite as egregious as this. I do want to flag for you all to be on particular alert for these no-fault attendance point systems, where workers get a certain number of points. I have seen so many problems with these automated systems. We even have some employers now have like motion trackers that track folks throughout the warehouse. For folks in call centers, we have call trackers where people are on timers throughout the day. I think that those automated systems are also really important because folks act like they are free from bias. This is not a boss singling somebody out here. Often individual bosses don't even have clear-cut control over those systems. But somebody, whether it's HR, somebody at IT, needs to go ahead and put the adjustments in the systems because we don't want to see somebody, for example, losing their job because they're making 3 fewer calls a day while they're on their bathroom breaks. Even those automated systems need to be updated. The entire metrics performance evaluation system needs to be looked at whenever there's a worker with an accommodation. So be on alert for that. Don't assume just because there's no person expressing hostility that this isn't retaliation or interference with someone's accommodation rights.
Yeah, on that exact same note, I would just say that if we imagine the same scenario here, but without the supervisor explaining the deduction, it's a harder case to prove, but it doesn't mean it's less legitimate. And so we need to be looking for, if the supervisor didn't give that reason, what is their purported reason for, the lower review scores.
Absolutely. And again, use the EEOC regulations to your advantage. There are some fabulous examples in there of that exact thing, where there's these no-fault policies, these automated policies. The EEOC calls it out as retaliation. So we definitely have some good guidance there to fall back on and help you make the case.
And so moving on to lactation accommodations. Thank you both for chiming in on that scenario. It's really helpful. So breastfeeding and chest feeding is a public health imperative. Human milk protects the babies from infections, illness, including diarrhea, ear infections, pneumonia, so many different health benefits. Lower risk of asthma, obesity, diabetes, sudden infant death syndrome, or SIDS. And for the mother as well, mothers who breast and chest feed have a decreased risk of breast and ovarian cancers, lower chance of diabetes after gestational diabetes, so many different health benefits. And even just not counting the health benefits, just looking at it from an employer's perspective, mothers or parents who give human milk to their children miss less work days due to illnesses. So because this human milk is protecting both the mother, the parent, and the baby, they actually miss less days of work because they are protecting their children from these illnesses. And so these lactation accommodations are important. Why? Because families, they want to breast and chest feed. When you're looking at deliveries in the hospital, over 94% of families in California report intention and initiation, yet by 2 months, only 38% are exclusively providing human milk to their babies. Workers who had access to both time and space for expressing milk are 2.6 0.3 times more or as likely to be breastfeeding exclusively at 6 months. And research shows that workers who receive support to express milk at work are more likely to return from maternity leave and not to further extend their leave. So if they know they're being supported in their workplace, they're not going to be as hesitant to return or look for another place to work that is more supportive. They have improved morale and better satisfaction and are more productive and loyal to their employer. And 41% of breastfeeding workers are shown that they are not provided with reasonable break time. And then 55% are shown to not have access to that private space. And combined, 60% do not have access to both break time and space. So even with all of these laws protecting them, there's still the majority that are not receiving the protection that they deserve in the workplace. So why are lactation accommodations important? It's not a free break time for mothers and parents who are expressing their milk. It is a health need. Lactating employees must express milk about as often as their baby feeds. We don't like to put times on it because everyone's different, but typically about every 2 hours. It's not, can you hold it for 6 hours or until you get home? That can actually cause issues with milk production. So then many times we see when families go back to work, they no longer have enough milk to keep up with their baby supply or need. And also, more importantly, to avoid health complications for the lactating parent, you might not want to give them an extra 30 minutes to express their milk. Well, now they're going to be out for 5 days because they have mastitis, which is a breast infection. They can have pain, engorgement, or breast inflammation, plugged ducts, abscess, so many things. And it's just not comfortable. It's not a simple hold it. It's a need. It's a bodily need. Just like you can't really hold a sneeze or you can't really hold your bladder. It's a need to express that milk.
Thank you, Brenda. So I'm going to give an overview of the laws both in California and federally that protect or impact breast and chest feeding at work. As we mentioned with a lot of the laws in this area, it's kind of an interwoven web. So I'm hopefully going to just hit on the key pieces of the puzzle that each of these laws adds. So first we have section 43.3 of the Civil Code, which protects breastfeeding in public in California. 2 sections of the Labor Code here, 1030 and 1171.5, require reasonable accommodations for lactation in the workplace, and they require that these labor laws be enforced regardless of immigration status. So we know that immigrant employees can still seek these protections. We have case law here, DFEH versus Costas Tacos, where the court held that breastfeeding is an act intrinsic to being female. So that goes back to the fact that discriminating against someone because of their pregnancy status or their lactation status is discriminating against them based on sex. AB 2386, which was passed in 2012, clarified that under FEHA, breastfeeding employed mothers are a protected class. So again, it's about protecting women and pregnant and parenting employees from discrimination. And finally, the pregnancy regulations within FEHA, which define lactation as an other related medical condition to pregnancy. And then moving forward for the federal laws that are impacting breast and chest feeding at work, we can start here with Title VII. That prohibits lactation discrimination for employers with more than 15 employees. Title IX prohibits lactation discrimination and requires accommodations for both workers and students at educational institutions that receive federal funding. If you're interested in that topic, Jessica and I last year put on a training about that specific topic, the educational institutions and the rights of pregnant and parenting students. So you can find that online. Then we also federally have the PUMP Act, part of the Fair Labor Standards Act, that requires lactation breaks and space Momentarily, Jessica will go into the details of what the Pump Act requires for those lactation breaks and spaces. And finally, the Pregnant Workers Fairness Act, again, just solidifying and making these protections better and stronger, requires reasonable accommodations for lactation with employers with more than 15 employees.
It really is a big web there. Thank you for that overview. As you see, you could probably cross-file under many laws here. I hope you don't need to, but I hope you're on alert for it. So I'll go over the Pump for Nursing Mothers Act, also went into effect last year, and really changed things. You know, there has been federal workplace protection for lactating workers for just over 10 years now. But with the passage of the Pump Act, more people became covered under that law, and the enforcement mechanism was strengthened. So folks who have had their lactation rights denied can go to the Wage and Hour Division for help, or they can file lawsuits. And unlike the world we were living in before the Pump Act, there is now the potential for the full scope of FLSA damages here. So it's definitely worth taking a look at. So under the Pump Act, employees are entitled to lactation break time and space for 1 year after birth. Those breaks have to be provided as needed, and the lactation space must be not a bathroom, free from intrusion and view. So a lock on the door, curtains on the windows. They must be equipped with a place to sit and a flat surface on which to hold a pump. The space needs to be functional as a lactation space, meaning, you know, no hazardous materials. And again, it has to be available as needed. Now, if you Google the Pump Act, you're going to see that some of these details aren't fleshed out in the actual text of the law. For example, the fact that someone should have a place to sit, right, and be free of hazardous materials. But I'm taking that from the Wage and Hour Division Field Assistance Bulletin, and I just put the link in the chat there in case that's helpful to you all. So the Department of Labor has interpreted this to mean not only those core basics, free from intrusion and view, not a bathroom, but also functional, go figure. The key differences here from California law that I think are worth pointing out is, first of all, there are no exceptions to the break time or space section of these requirements for employers with more than 50 employees. So there's no reasonable efforts language there when it comes to the larger employers. It must be provided. And there are only extremely limited exemption options for employers with less than 50 employees. When we were advocating for the passage of the Pump Act, we heard from the Department of Labor that in the 10 years of enforcing an extremely similar standard nationwide, they had never found an instance where there was a true undue hardship. And all of the language and all of their materials points to the fact that there are creative solutions in every industry. So a true undue hardship is going to be pretty rare. So let's assume that your folks are covered, except for in the most rarest of circumstances. And remember that when it comes to providing those breaks in space, for most employers, there is no wiggle room there. There is no undue hardship standard for those with more than 50 employees. Also, unlike California law, under the Pump Act, lactation break time does not have to run concurrently with any other already provided breaks. I've seen a lot of policies in California that still maintain that language, and it's getting employers and employees in trouble. If you work with any institutions, especially the schools, who have lactation policies, definitely want to keep an eye out for that. We see a lot of employees who've been told that they have to pump during their lunch break, even though that doesn't meet their own health needs, right? We want to avoid that. And then California law is very clear that these breaks are unpaid. Under the Pump Act, the breaks are also unpaid in many circumstances, but there are several circumstances where workers should still continue to be paid. For example, if someone's completing work, of course they should be paid. If, for example, they're pumping while answering emails, they would be paid. Whatever state they're in, they should be paid. But we also see, for example, folks who are in salaried positions. We've seen a lot of employers think that they could dock pay from their salaried workers. Want to be on alert for these pay issues. They keep coming up on our helpline, and I think a lot of workers are really struggling with that. There's a lot of folks who are taking an economic hit that probably shouldn't. And at the end of the presentation, I'll give you a link to our explainer on lactation breaks and when they should be paid or not. Next slide. Okay, so bringing it all together, of course, California law and PWFA also require lactation accommodations indefinitely. So the Pump Act covers folks for a year. We don't have that timeline when it comes to PWFA. We don't have that clear of a timeline when it comes to California law. So if somebody wants to continue pumping or taking lactation breaks at work after a year, that is fine as long as it's reasonable or not causing a serious disruption to the employer's business. And in addition to the federal standards, California does require that the room be clean, have access to electricity, a sink with running water or refrigerator, or if not possible, some other cooling device. And there's also supposed to be a policy on lactation accommodation. I know a lot of folks are falling short of this. Hopefully people are catching up now that there is a full slate of laws that are requiring lactation accommodations at work. But let's do a scenario just to see how this could play out in practice. Oh, or Brenda, talk us through the practice.
Yeah, just offering a few visuals and examples. It doesn't have to be a fancy spa-like, although lactating people will really appreciate it. It doesn't have to be very fancy, as long as it's private and accommodating. Even if it's a shared space, as long as it's clearly labeled that it's in use as a lactation space during that time. Some people use their boss's offices because they say, hey, we can't provide anything else, but having a sign out in the front that nobody's going to be interrupting and is available when that lactating person needs it. So again, as needed, it's up to the person who is producing the milk when they feel that they need to express that milk. And just like with pregnancy, workload and productivity should be adjusted for that, change in time during the workday. And there's no need for a doctor's note as well for this. And, just keep in mind, some may experience that peer-to-peer harassment. So that is a form of retaliation. So even if the employer is being accommodating, but the peers are making comments and making it hard on the lactating person's workday because they're taking these breaks or because they're taking on more work due to them taking the breaks, that should not be happening. That harassment should not be happening. And the space, here are just some examples. You can look online easily to see different solutions. There are many handbooks out there. Jessica is going to be offering a lot of resources at the end. If just need support finding a way to accommodate, there's plenty of people that can support to find a solution, including myself and people on this panel. So in this scenario, Sam, an elementary school teacher and parent to a 2-month-old, needs pumping breaks every 2 hours. The school principal tells Sam it's just not reasonable for them to take breaks that often. Teachers are one of the biggest employees who struggle to get accommodations because nobody wants to disrupt the classroom and the teaching. And Sam is struggling to get the classroom coverage they need to take breaks and is about to quit their job. So an easy, simple solution for this is the principal themselves can cover It's just for a little bit. How many times do they get like substitute teachers? Jessica, I don't know if you want to add anything else to this scenario, or Juliana.
Sure. Yeah, I think it's so important that this worker is about to quit their job. Depending on your role, you might have a different perspective on trying to keep them in their job. But I would just say, remember that the standard for lactation breaks is that they have to be provided as often as necessary. It is not the employer's choice. It is based on the worker's needs, and it is the employer's obligation to provide the conditions necessary for the employee to actually take those breaks as often as necessary. So it's on them. But I really like this example, and I'm thankful, Brenda, that you raised all of the health issues at the beginning here, because especially since this is a crowd of attorneys, I do want to point out that a failure to accommodate lactating workers has been found to be a basis of constructive discharge. And we've seen that in a handful of really compelling cases. If a worker does decide to quit because they just can't go on missing their lactation breaks, you should definitely be looking into constructive discharge. There is now some good case law to that end, especially considering the severe health impacts, both physical and mental, that this takes on people.
Also, just to point out that in all the laws that we're looking at that can support and accommodate these, this is now also Title IX applies to it as well now. I don't know if that's what you were going to say, but I did want to point that out because we didn't dive deep into it. But that's another one to add to the list of laws that are being broken.
Yeah, Sam could probably be suing under 5 different laws here.
Yes, I would say you both just hit the 2 points I had. The first was that this really sounds like constructive discharge to me, a type of wrongful termination, and that, yes, in the school context, we would have to look at Title IX as well.
Yeah, so now we would like to open it up if there are any questions. Go ahead. There are plenty of experts here who would love to just support in any way that.
You can use the Q&A options. While you're doing that, I'm just going to put in the chat. We have a slide with resources that's going to be emailed out to you all. I'm also just adding, I know I'm so thrilled with the EEOC regs. I just put those in the chat as well, in case you want a quick link to those. And then in terms of resources, we also have a bunch of resources that might be helpful for you. While we wait for any questions, Julianna, do you want to go to that slide? Yeah. So as I mentioned early on, this is really a whirlwind tour of these regulations and laws at the state and federal level. But we have done some advanced training for plaintiffs' attorneys on PWFA and PUMP in partnership with NELA. We also do provide healthcare provider resources in case useful to your clients when they're trying to document their needs. You can check out that guide, also from pregnantatwork.org, the Center for Work-Life Laws Resource Center. And then here's a link to the Guide to Lactation Break Pay. And then finally, if you need help, we're really desperately trying to make good precedent on the Pregnant Workers Fairness Act and PUMP. So we're happy to assist you or send your workers our way if they need support. Oh, and I see a question.
Oh, perfect.
So someone asks, can you elaborate on infertility accommodations under PWFA?
Absolutely. So infertility is a pregnancy-related condition, in the birthing parent, the parent who can get pregnant. And we have, it is very clearly spelled out in the EEOC regulations that would be a cause for accommodation. So For example, somebody might need time off to go to doctor's appointments, to get fertility care. They might need some adjustments at work if they're managing side effects. We know people who undergo fertility treatment often have miscarriages and might be entitled to leave to both physically and mentally recover if they do have a pregnancy loss. Anything that worker needs as they seek to become pregnant or carry that pregnancy would be covered under the Pregnant Workers Fairness Act. And I will put a link in the chat to our guide for workers on that, which might also be helpful for you all. One thing that I will flag is I know when it comes to infertility treatment, a lot of folks are feeling a bit embattled right now. Well, fertility treatment or infertility treatment with any assisted reproductive technology right now, it's in the news. It's a part of this just really unfortunate culture war that we're seeing right now. So again, I want to remind folks that the Pregnant Workers Fairness Act documentation requirements are very worker supportive and that you don't have to include a lot of details. So if somebody is nervous about backlash, of course the backlash is illegal, but they might be nervous anyway. Use a PWFA documentation form. You don't have to fully disclose every detail of what treatment is going on. And definitely check out our resources for some tips on how to do that while also getting the accommodations that you or your client needs.
And thank you for that. There's one more question. I know we're running close to time. How long after returning from leave is someone generally considered protected from retaliation, not lactation related?
I don't know if I have a clear timeline. I definitely, the closer to returning from leave that an adverse action occurs, the stronger the case is. But we have seen folks kind of have the snowball effect where as soon as they get back, they kind of feel like they're under a bit more scrutiny and things just keep getting worse. I've seen that a lot. But Juliana, do you have any other thoughts on that?
I think you're exactly right. And I've also actually seen the reverse happen where someone got back from a leave and they all, like, most of their work was taken away from them. So they were given less and less responsibility. And then their employer made it out to seem that, this person couldn't handle those responsibilities, but they believed, it was retaliation for taking leave in the first place. But yeah, in general, I would agree with your assessment that like the closer to the leave, the stronger the case. But just because it happens, 6 months later, a year later, doesn't mean that, like there's not like a statute of limitations issue there if they're still retaliating against you.
I would say, and just to add, like just if you're ever dealing with a family, if they can start to make little notes, you just never know when little things are going to start to add up. And it's really hard to go back and think like, oh, on this date, this happened, but I don't remember the context. So if you are, working with a family or who is already starting to feel like any kind of effects of this, to start, making notes of that just in case too.
Yeah, I think that's a great tip. And we are running out of time now. So I think we can wrap up. Thank you to the co-hosts, to everyone who attended, and to LAAC for hosting the webinar. And I'll turn it over to Jocelyn at LAAC to end this up for us. Thanks, everyone.